Hello, everybody. I think everyone has had their lunches and have had a bit walking around, so not sitting all day long. If I sit, then I don't really see you. But please take a seat. My name is Carmen Turk. I want to welcome you all in my home country. It's nice, it's not raining today. This is the #1 workshop of this year's EuroDIG. And it's about realizing rights online. So from human rights discourses to enforceable stakeholder responsibilities. In addition to being Estonian and probably bringing gender balance on the stage, I'm also a litigating lawyer from an international law firm, and I teach in University of Tartu, and occasionally I'm an expert for committees attached to European Council of Europe. So human rights matter, yes? This is what we have discussing from the very early morning on till now. But however, talking about them is not enough. And this is what this workshop will be all about. We will try to explore what needs to be done in order to effectively realize human rights online. So human rights discourse must lead to an enforceable framework of rules. And this is what we try to discuss from very different angles. If you use social media or Twitter, please use hashtag like hashtag #NetGov or hashtag internet rules or hashtag human rights or hashtag intermediaries or something that is relevant to the session. And then please do use Twitter, because this is the way to get out of this only 600 or 700 people to the wider public anyway. So without any further ado, I will introduce our participants on the stage. And the first one, I have an honor to introduce to you the first speaker and this great panel afterwards. And the first speaker will be talking about human rights in internet politics, about the reality, and this will be Dr. Wolfgang Kleinwachter, who is a former member of the ICANN Board of Directors. Of course, in addition, not being able to cover all significant affiliations, he's an emeritus professor in University of Aarhus. However, in past, also universities of Moscow, Washington, Tampere, just to start with. And today, his main commitment goes with the Global Commission of Stability of Cyberspace. Thus, please, as promised, discussion of normative approach to the internet politics. Please, the floor is yours.
Okay, you know, the internet is a human right. Internet access is a human right. There's a broad consensus about the community, and in some countries, like in Finland, this is meanwhile part of the constitution. I think there is no doubt about it. However, we have seen again and again violation of human rights in the internet daily practice. You know, we have measures by governments to restrict freedom of expression. We have a lot of problems with privacy. The right to freedom of association is challenged several times. So that means human rights is really in the center of the internet governance debate. If you go back 15 years, when the United Nations World Summit on the Information Society started, so it was already clear that in the so-called WSIS, the World Summit on the Information Society, human rights has to play a crucial role. And at this time, some people came and said, okay, we have to rewrite the human rights in the digital age, because so many things are new, and we have to adjust the Human Rights Declaration from 1948 to the new information age. And in the center was Article 19 of the Human Rights Declaration, and some people argued that this right to freedom of information has to be enhanced into a freedom of communication, because the internet offers more interactivity, and we have to be more precise now and have to introduce a new category of human rights. But in the process, it became clear for many participants, and this is relevant also today, that if you have an existing right and you want to introduce a new right, the risk is high that you undermine the existing right. And if this proposed new right is the subject of negotiations among conflicting parties, probably at the end of the day, you get a weaker right than you had before. So, and finally, if you go back to the adopted documents from the World Summit on the Information Society, you will see that the main reference is to the existing Human Rights Declaration from 1948. Because in the 3 years of negotiations, it became very clear that probably if we move too strong to a new generation of human rights, the unintended side effects will destroy what we have. And, 10 years later, it was a very wise decision by the Human Rights Council of the United Nations, which adopted a resolution saying that the individuals have the same individual rights. They have offline, also online. This is a very simple language. Everybody understands it, and it makes very clear that there is no need to reinvent human rights for the internet. We have it already. We have to use it. And this brings us to the second part also of our discussion here, and this is the implementation. That means while there is no need to reinvent the rights, there is a need, to guarantee that we can enjoy these rights also independent from the space in which we operate, in particular in the cyberspace, which is borderless. So I stop here because this will be part of our discussion, and back to you, Carmen.
Thank you. We were planning to have it like this, that we are all trying to keep it quite short and say very short interventions and then really open it up for the discussion. So whatever kind of comments, thoughts, or ideas you already have, please write them down, and we would really, really like to hear them in 15 minutes or so. So the next we will hear, the next panelist is going to talk about human rights from the perspective of ICANN by Markus Kummer, who is, according to World Wide Web, resides in Geneva and is journalist hidden inside of a diplomat. He started from a Swiss diplomatic services, ending up with UN, IGF, WSIS, ICANN, and so forth. So please, Markus.
Thank you, and good afternoon. It's my pleasure to be here. Yes, you rightly said I started my professional life as a journalist, and there I learned a good old saying, don't let the facts get in the way of a good story. So that was maybe the beginning of fake news. But I'm also the board liaison on human rights. There's ongoing work going on, but I'm speaking here in my personal capacity, and I don't reflect the consolidated board view. But let me say at the outset that ICANN, by carrying out its mission to make sure that the internet functions, ICANN is not the only organization, but ICANN contributes to the coordination of the domain name system, to the good functioning of the internet. And by doing that, ICANN does a lot actually to promote some basic human rights, like the freedom of expression beyond borders. It's like Article 19 predicted in the early 50s. We have this right now thanks to the internet. The human rights was not part of the discussion on ICANN to begin with. It sort of came up a few years ago, and when it was first mentioned, especially by non-commercial stakeholder group, some board members said, what's that? We have nothing to do with human rights. But then we had to be reminded, hang on, who is privacy? This has very much a lot to do with human rights, and obviously freedom of expression, freedom of assembly, these are core values in the human rights field. So gradually discussion started and took off and was part of the IANA transition, and it is now in the ICANN bylaws as a core value. ICANN respects human rights as a core value, but obviously ICANN does not enforce human rights, and that's also most part of the discussion, human rights are obligations states have, not private organization as such. So there was a very long discussion, and it's a difficult and complicated discussion. It's not that easy, but in the UN context, there had been work carried out. We have UN guiding principles on human rights for private enterprises that define the obligations and make it also clear, while private enterprises don't have the same obligations as states, they nevertheless should aim to respect obligations. And this is in particular relates to labor standards for big multinational companies who operate in developing countries. They should not exploit local workers, but they should respect higher standards there. But the discussion also made it clear that these UN guiding principles cannot be translated one-to-one to ICANN, as ICANN is a slightly complex organization, slightly different from the traditional enterprises that the UN guiding principles apply to. But as it happens now, we have a framework interpretation that is out for comment, and I encourage you to look at it. It's up on the ICANN website. It makes it clear what the bylaw means and what it does not mean. And again, it's not here that ICANN should be active outside its mission, but only when it relates to its mission. But this is work in progress. We don't know yet what it will lead to. It could lead to human rights impact assessment in the policy development of ICANN. But this is, again, it's complex, it's highly specific, and there are also possible legal consequences that have to be analyzed. So we right now, the ICANN community is in the process of assessing this, and we will see where it will lead to, and I will stop at that. Thank you.
Thank you, Marcus. So next, in order to open the floor soon, we will move on to the Council of Europe, from where we will discuss a bit the standard setting for the 47 member states in the Europe. And with that, we start with Charlotte Dion, who is working for the Council of Europe regards to internet governance, freedom of expression, or other human rights as well. Before that, she has done a lot of good work and appreciated works for minors and vulnerable groups, but now she has been tackling a lot the subject theme of this conference. So without further ado, floor is yours.
Thank you. Yes, my name is Charlotte, and I'm in the Media and Internet Division of the Council of Europe, which is part of the Information Society Department. Generally, for all of the Council of Europe and its work, of course, central is the European Convention on Human Rights and Fundamental Freedoms, and the very rich body of case law of the European Court of Human Rights, which gives all of us binding guidance really on how member states should be applying their human rights obligations. One of the main doctrines of the court has been the doctrine of dynamic interpretation. And this means that the interpretation and application of human rights cannot be static. It evolves together with the evolution of society. And society, of course, has evolved. There is important technological changes that we are discussing today. There are also other changes. Societies have become more diverse. Societies are grappling with much larger levels of inequality. But when it comes to the technological evolution, the effort of the Council of Europe standard setting has really been to inject non-binding soft law standards to help governments, judges, national court workers to see how the fundamental principles of the Council of Europe, human rights, democracy, and rule of law, can be applied to the new challenges. When we say human rights apply online as they do offline, what does that really mean? What does it mean for the freedom of expression, for instance, to be enforced in the online space? And here our standards are different instruments, over 60 since the 80s, recommendations, resolutions, declarations that provide guidance and help on quite specific issues to determine exactly how to live these human rights articles in daily life. Some of the standards are general, for instance, media pluralism, digital content of media, what is the public service value of the internet, etc. Some are also very specific on intergovernance related issues, and they really provide guidance on technical matters. There are 2 declarations, for instance, also related to ICANN and the important work that ICANN is doing. And there are recommendations that determine very clearly what the negative and positive obligations of member states are regarding the online space. How to maintain an open and safe network for the internet, how to ensure that there is no interference to the freedom of expression, for instance, unless the interference in line with Article 10 of the European Convention has a clear legal basis, is serving a legitimate aim, is necessary in a democratic society, and is proportionate to that aim. And then there are standards, of course, also reminding states of the positive obligations that they have. The positive obligation of providing an enabling environment for the freedom of expression. And this, importantly, as we have heard already, includes also to provide an environment where private actors behave in line with human rights as well, where private actors are aware of the responsibilities they have towards the users. And we are differentiating between the obligations of states that stem directly from their human rights commitments and the responsibilities of intermediaries in line with the UN guiding principles and also in line with the with standards developed by the Committee of Ministers of the Council of Europe to respect human rights, rule of law and democracy also in the online space. And I want to mention here just 3 of many recommendations just of last year. There is the Internet Freedom Recommendation, which provides indicators to states and helps them establish what really they should strive for in their daily policy making, in their legislative endeavors, and in the application of articles in courts. With respect to the different rights, with respect to freedom of expression, privacy, right to assembly, etc. Then there is the Internet Governance Strategy, and I think that is also important. That was adopted last year, reminding states again of the multi-stakeholder principles that must apply to the Internet governance, and also very much again underlining the responsibilities of private sector actors. And this is really where we are today. We are currently in the process of developing a draft recommendation on the roles and responsibilities of internet intermediaries. And this is where the next speaker will speak about more in detail, but this is important to ensure that we are reminding really all of ourselves that this is a multi-stakeholder environment where states have obligations, but where also intermediaries have certain responsibilities.
Thank you, Charlotte. So last, but in no means least, we try to look into the human rights and internet politics from the angle of regulating intermediaries. So as Charlotte just said, that it is a reality that internet is all about private persons. This will be outlined by Matthias Kettermann, who is a postdoc fellow in University of Frankfurt, lecturer in the University of Graz, and studied, of course, in many other very established educational institutions like Geneva and Harvard Law School. To abuse the right of self-determination of Matthias Kettermann, in addition, one of the most perfectionist professionals I have had an honor to work with, and a very cute person in addition. So, the floor is yours, Matthias.
Thank you very much, Carmen. What a lovely introduction. The importance of this panel is to show you how we can apply existing standards to the online world, how to realize human rights online. And one of the ways to do it is to develop, on the basis of existing law, clear standards which are then communicated to states and to intermediaries, that is, to internet companies. One example of this approach is the Council of Europe's recommendation to member states on the roles and responsibilities of internet intermediaries. And I've had the honor to act as rapporteur for this group. We're still in the process of finishing the draft, but I'm able to share some of the key points we've worked on for the last 1.5 years. And we appreciate any input from your side. Let me first tell you about our approach. We do not try to invent the law. We try to establish existing legal principles and try to make them as clear as possible and as easy to understand as possible, so that states and intermediaries have a clear guidance on how to regulate content, how to deal with human rights challenges. Our recommendation has 2 parts. We have included a section on the duties and obligations of states and a section on the responsibilities of companies. So we acknowledge that in the internet world, it's not only states that have an obligation to ensure that human rights are applied, but also, and in the context of freedom of expression, for instance, primarily it is internet companies that have to ensure that on their platforms, human rights are applicable and applied. We acknowledge that the world is constantly evolving. The roles and responsibilities of internet intermediaries are changing, they're growing. They have, by now, become extremely important players. They connect users to the internet. They enable the processing of enormous amounts of data. They host and store web-based services. They develop applications. They also host and index content. In doing all those things, they have to agree to certain human rights frameworks, and they have to make sure that in their actions they do not violate the human rights their users, we, all of us, are entitled to. Regarding states, we want to make sure that states, in dealing with internet intermediaries, accept and apply the principle of legality. That means especially that any request, any demand, any action by public authorities which is addressed to internet intermediaries must be prescribed by law. The group thinks that any informal approach by governments to intermediaries leads to insecurity and can be detrimental to human rights. States also should not absolve themselves from their obligation to secure human rights and fundamental freedoms for all by delegating those functions to internet intermediaries. Encouraging intermediaries is okay, but delegating functions to ensure human rights to intermediaries by states is not an approach we find conducive to securing human rights. Further, any legislation which applies to internet intermediaries must be clear, it must be accessible, it must be predictable as to the effects. New laws especially have to be checked against their potential impact on human rights. The new German law on enforcing human rights online, for instance, the EuroDIG, is very problematic in that aspect. We have also included clear safeguards on selected human rights, such as the freedom of expression and privacy and data protection. Again, we tried to point out that any demands, any requests by states which are addressed to internet intermediaries regarding personal information must be based on law, and those requests must pursue one of the legitimate aims foreseen in the European Convention on Human Rights, particularly Article 8. But it's not only states that need to ensure that human rights are realized online. Internet intermediaries have enormous responsibilities with regard to human rights and fundamental freedoms. They should, we recommend, they should in all their actions respect the internationally recognized human rights and fundamental freedoms of their users and of all third parties who are affected by their actions. They should engage in regular due diligence assessments regarding human rights. They should engage in regular assessments of the possible future human rights impacts of their policies. And they should seek to ensure that their actions, be it on a company level or through algorithms, do not have discriminatory effects on their users or on other parties. We believe firmly that internet companies need to increase their accountability and transparency, especially the process of developing, changing, and applying terms of service agreements must be as transparent, as accountable, and as inclusive as possible. Users should be actively engaging in those processes, and companies have an obligation to open up those processes and open up the discussion on how their terms of service are applied. Internet intermediaries should respect the rights of users to receive and impart information, opinions, and ideas. In moderating content, they should not conduct general, non-targeted filtering to detect unlawful content. All measures which are taken to restrict access to or to remove content on behalf of a state should be effectuated through the least restrictive means possible. Regarding access to user data, we encourage companies to keep with the principles embodied in the Council of Europe Convention 108 on automated processing of personal data. We also firmly believe that that intermediaries need to ensure effective access to remedies for their users. And this includes clearly designing this access to remedies in the terms of service and communicating that effectively. And finally, intermediaries, we believe, should engage in targeted age and gender-sensitive efforts to promote the awareness for all users of their rights and freedoms online, both vis-à-vis states and vis-à-vis intermediaries, including and in particular information about applicable complaints mechanisms and procedures, because we will only be able to realize human rights online when we know which these are and who's responsible for securing them. Thank you.
Thank you, Matthias. So we would really love to hear your opinions, because these are the subject themes that interest or affect all of us. Like on Sunday, where after the horrible London Bridge attack, Prime Minister of UK, Theresa May, stood up and said that whatever we are doing in the future, one thing is for sure, we're going to need internet rules in order to avoid all the safe places for terrorists and so forth. And this went viral on Twitter. So why? Why do we all care about it? Whether it's because we can feel that it's our freedoms that are being balanced against the security of a community, or what are the reasons and how to best achieve this? This is what, in the end, we would as a society and then this workshop, would like to hear your opinions on. So any hands? I think we have microphones going on. Or remote participants? Sim. I think, yes, you have to actually walk to the microphone.
I just have a quick follow-up question to what Matthias was talking about earlier, and then I'll a small remark on May. You told a lot about what should be done, but in my opinion, a lot of the stuff is not about the rights itself. Maybe some users are even aware of those, but enforcing those rights and actually going after those companies where the profit motives might, come in conflict with human rights, or where they have a relationship with the government which is not really following the human rights, so to say. And on May, I think that it was just more, propositioning something that would look that she's doing something, and not really thinking clearly that cryptography should be banned, and we will lose Telegram and all the rest of the things that allow communication to be done freely, securely.
Anyone from the panel to directly try to give an idea or remark back on how it can be actually enforced? Because the human rights are here, we all have them online, offline, so enforceability is the #1 question. Matthias? Any Matthias?
First of all, I think the relationship between states and companies is multifaceted. That is to say, in certain circumstances, companies need to be protected from states, and they need to be protected from overreach. Certainly, in certain circumstances, it is the other way around. States sometimes also need to be protected from companies which have by now have a global reach and are and have a turnover that equals or surpasses what some states have in a year. However, I think the key question we have to ask ourselves is who can effectually implement human rights? And I think if you look at that this way, you will come to the conclusion that each actor has its specific roles and responsibilities. States need to ensure that the human rights of their citizens are protected. Those citizens do not stop being citizens when they become customers of a company. That means that even if you are a customer of a company that might be headquartered outside of the territory of your home state, you still enjoy the protection of human rights that you as a citizen of that state have. Companies need to be aware of that, and they, as responsible corporate citizens, also have to ensure that within their area of responsibility, in keeping with the RUGI approach of the United Nations, they do not violate human rights. So it's not an either-or question, but rather the answer would rather be that every actor is responsible within its own sphere of influence for keeping with and ensuring the human rights which apply to them.
Just to add to that, and I agree with what was said, we say the rights, if we take rights as kind of agreed, we do have standards, we know more or less how we would like things to be. The enforcement really, I think there we sometimes lose sight a little bit of the rule of law and of the differentiation of original state powers, which are really legislative, adjudicative, and then executive. And I think here what we are trying to reestablish is that the legislative power clearly lies with states, and they need to develop the rules and standards of what exactly can be taken down, how and in what circumstances. The adjudicative, in terms of when exactly does an individual situation require intervention, that I believe there we have a number of discussions ongoing simply because courts alone are having difficulties in playing this role, simply because they traditionally take a lot of time. But the enforcement part, that is taken today also by intermediaries, because they are actually the ones that are deleting certain content or that they are sharing certain personable identification of they are disclosing user data. But what we need to ensure is that we keep those different functions separate and that we have those checks and balances. And this, to be said for the intermediaries, we are saying they need to also respect human rights. They have their terms of service agreements and they have the right to do that. We are saying simply those terms of service and community guidelines must be transparent. It must be clear what exactly, it must be clear to users what exactly do they allow on their platform and what do they not allow. And in addition, those terms of service agreements also must be in line with general human rights standards. That means they cannot in themselves be discriminatory. They could, for instance, not have terms of service agreements that say women can can have more rights than men or something like that, just to take a silly example. But I think at the current moment, what needs to be done really is to dissect what exactly happens with the legislative function, with the adjudicative, and then with the enforcement. Who enforces how and when? And that is really how we only can come closer to finding standards on that.
Thank you, Charlotte. You?
Thank you very much for the great ideas you shared. I want to be a little controversial. I know the great track record of the Council of Europe in creating soft law and creating recommendations. Now, considering the fact that intermediaries is something that is global and many other people want to, be part of regulating intermediaries with regard to human rights, is the Council of Europe the right place to make these kind of recommendations? Or shouldn't it rather be ICANN or the UN or the ITU or someone else pitching in and trying to get more voices? Because it doesn't really help everyone on the planet if Europeans have a right to be part of the debate about terms of service agreements, but not everyone on the planet.
Thank you. Who would like to take it? Maybe I can, or Mr. Kleinwachter?
Well,
Maybe
I can briefly react and say definitely not I can. I mean, the human rights bylaw makes it clear that it only relates to ICANN's core mission, and the framework of interpretation expands on that. And this would clearly be outside the scope. But the OECD has actually already produced guidelines on role of intermediaries back in 2011, and there may be an interaction with the Council of Europe, as there's an overlap in membership. Not every OECD member is a member of the Council of Europe, and the other way, vice versa, but there's a big overlap between the two, and I would be interested in hearing from those who are involved in the Council of Europe how there's an interplay, if at all, between the OECD guidelines and the ongoing work in the Council of Europe.
Dr. Kleinwachter.
I can only echo Marco saying, ICANN is not the place for managing these human rights. As the former and the acting CEO of ICANN always has argued, ICANN is not the cyber police. So very clear, ICANN has to deliver names and numbers. And if our aspects in this process of delivering names and numbers which touch human rights, then ICANN has to be carefully not to violate the human rights, but it has not to be active in this field. And why I see the argument of the gentleman here, I would not underestimate the role of the Council of Europe in the global debate, because the Council of Europe has not only the Human Rights Convention, it had also the Court of Human Rights. And I think this is the only real instrument we have, the only mechanism where you can go in a case of violation of human rights to a court and can ask for a decision. There are some procedures how you get a decision out of the Human Rights Court, but this is a huge achievement, because if you are, as a state, a member of the Human Rights Convention of the Council of Europe, so you have to join the Human Rights Court, and then you are obliged to follow the decision. So we do not have such a mechanism on the global level. So this is really unique, and insofar what the Council of Europe is doing, with its member states, which is much more than the 28 members of the European Union. You should not forget it. The Council of Europe includes nearly all former Soviet republics as members. So this is a big achievement, and we should not underestimate this. However, I see that outside of the member states of the Council of Europe, there are a lot of other human rights issues which probably, should be treated in a similar way, or how we can do to bring mechanisms which are working in Europe to the rest of the world. And here I see an interesting development in the United Nations Human Rights Council. The council was just established a couple of years ago. Before it was the Human Rights Commission, and it has now an extended mandate. It can ask for reports, national reports, and can send fact-finding missions to certain countries. So this is helpful what the Council can do. And even more, it is now moving in a direction where for special issues, the Human Rights Council appoints special rapporteurs. We have a special rapporteur for freedom of expression, And the reports of these special rapporteurs are really a big instrument because, you know, it's not a court, he cannot make a decision. But in his report, he can use an instrument which is also very powerful, and that is naming and shaming. That means, and this goes both for governments and for corporations, because corporations do not like if they have a bad image. And if they are mentioned in a report of the special rapporteur on freedom of expression in the United Nations context, that they ignore human rights or they treat their customers in a way which is in conflict with human rights. This is a big thing for a corporation. That means you have certain mechanisms in the reporting system under the special rapporteur regime in the Human Rights Council, which is not the solution to the problem, but it is an important instrument you should not underestimate. And the next step, which was taken by the Human Rights Council as the result of a German-Brazilian initiative, is now the special rapporteur on privacy. By the way, this is the result of the Snowden revelation when it became clear that both the president of Brazil and the chancellor of Germany, that their telephone were wiretapped, and so the German-Brazilian government came together to the United Nations and they will have to do something more. And after adoption of a resolution, now this new job of the Special Rapporteur for Privacy in the Human Rights Council was established. So he has just presented recently its first report, Mr. Katanaki, a lawyer from Malta. And if you go through this report, then you see exactly all the issues which we have discussed in the last 5-10 years about privacy in the digital age are now mentioned in the work plan of this special rapporteur. That means if you have a problem, send your message to him. He is open. He was recently in the ICANN meeting in Copenhagen and said, okay, I want to learn from you, but you know, we will push forward. And naming and shaming is a strong instrument. And I could imagine that we are looking, if we are moving forward, it's much more easier to work with such reports than to try to find legally binding solutions for problems. So that means you do not try to reinvent existing norms, but you feed, let's say, the mechanisms you have with cases, you know, with some problems, so that this can be discussed in an open manner by all stakeholders, so that you have more self-discipline actions which will bring governments and corporations which ignore human rights in a difficult position. This will not be the final solution, as I said it, but it's an important element which should not be underestimated.
And yes, the Council of Europe, as the guardian of the convention, this is how you do it, that you have a positive obligation for a state to create an enabling environment. So regardless of the fact that most of the cases are Mr. B against state A, it's all about creating positive obligation for the state in accordance with decades of convention that is a living instrument to create new obligations and responsibilities for all corporations. But now we have a question from Matthias.
Thank you. Just also a remark, I want to come back to this enforcement topic, because I think this is really now one of the key issues also for EuroDIG in the future. We celebrate maybe tonight in a nice party 10 years of EuroDIG, and we hope that there will be another 10 years of EuroDIG at least. I think in the first 10 years we spoke about a lot of the standards and the standard setting, and also today in this session until now we heard again of important things, of course, the three-step standards in the European Convention on Human Rights, that there must be the legal basis, and it must be proportional and so on. I think most of us, even the very young ones, meanwhile have some sense of it at least. I think it's much more important now that in the second 10 years we speak, so what was the effect of all these standards. We have this also enforcement, and we have, of course, the execution of judgments, for example, in the court. People read about the court cases, what the court decides, that state A has, for the 10th time, maybe blocked internet access, has then done sanctions to that. And then we read it and say, we can read, okay, it was an infringement of Article 10. But we never hear what happened then. And I remember very well at one of the last IGFs that was in one of the Council of Europe member states. 1 year later, they had invited one of the activists of the IGF and asked this activist, and I will not tell you the name now of the country, but they have asked this activist, was it a success that we spoke about all these standards on IGF there? And he said, well, just directly when the IGF took place. After that, I got even worse sanctions than I have ever got before. So we really have to concentrate what is happening. We have to concentrate on enforcement and what is really the effect of all that, what we are doing. And therefore, I think also companies, we spoke about of course, the enforcement by companies. I want to hear from the big companies, from the intermediaries, not only that they put on complaint mechanisms and whatever. I want to hear concrete cases where people complained and what was then finally the solution of the companies. So what did they concretely do? And how is it possible that we have all these red flyers here, so much hate speech on the internet? I do not say that everything can be solved by regulation. And I do neither say that everything is blaming and shaming, but Wolfgang is very right what he said. We need these reports, and they have to be discussed as a so wonderful event like the EuroDIG. Thank you very much.
May I just quickly reply? That is absolutely also what we at the Council of Europe think, and this is why we, among the standards we promulgate, have included one on the importance of transparency of those companies. If we cannot look into the black boxes of decisions that are taken on a daily basis, even by people and by algorithms, we are not able, as lawyers, as political scientists, to analyze them and to make them more human rights sensitive. So we need a firm knowledge basis. This is why transparency is so important.
Yes, please.
Just wanted to raise a question that I think is kind of undermining all the discourses that have been made, and actually they've been made also this morning, because I remember, I think the professor mentioned of the Cold War, we should try to avoid these things. And my question is about the fact that we need a long-term strategy in terms of something that we are facing new challenges and we need to adapt to those. But don't you think that in order to do that, we need to intervene a little bit more on education? I mean, Council of Europe does great resources. I personally represent the campaign of the Council of Europe against hate speech. And one of the issues that we have when we try to bring these things is that human rights, education, media literacy are not a priority yet. So it is like we are struggling, because I don't know who before said that, you know, maybe human rights are something that are there, but I wouldn't take that so much for granted. There are people that don't know anything about it, don't know what the Council of Europe is, what is available. So we have some resources, but it's like we haven't really succeeded in making them accessible to everybody, because we have to acknowledge the fact that there are people that have different access to instruction or things like that, while internet now at the moment is widely accessible to many more people than those who got education. So my question is, what do you think that states or governments are doing enough when it comes to education and in kind of implementing new strategy to introduce these new topics in the curriculum, especially for young people, because my thing is that if we need to face new challenges, okay, doing laws, punishing or naming and shaming, but there are short-term effects. We need something to change this attitude. When we talk about hate speech, that's why we really focus on education. We got manuals to try to eradicate this kind of thinking before it even can be born in the mind. But we don't find a lot of, I don't know how to say, many states that don't like really go into that. We got many states that are cutting education funding. So what are your opinion about that, your suggestion? How can you know, general and pan-European institution can do something more to push these steps?
I'll give the floor to some of the panelists because in the end, I think if you are looking for a long-term solution, I think the rule of law is still the one benchmark that we should try to uphold. And the necessary condition for that is the court system, transparency, public decisions. Of course, it is understandable that in internet you need quick remedy, so how the court system in the future will be able to tackle this in order not to put or give the possibility to making these decisions to only private companies. This is, I think, the main questions, especially for regards to vulnerable groups as minors. Charlotte, maybe have any idea?
Thank you. I think you mentioned an absolutely crucial point. Education and awareness raising is hugely important, and I think the general understanding for that is growing. Standard setting, just to come back quickly to that, is also in a way about preventing human rights violations. So I think I want to just carry the flag really for standard setting today as one of the ways of not only helping member states implement their human rights obligations, but also helping them do that in order so that they avoid new human rights violations, so that the court in 10 years, once the case has moved through the national court system and then comes to Strasbourg, will not have to determine that there has been a violation. And part of the standard setting has indeed also been to remind member states of this enabling environment, which means very much human rights awareness, education, make people aware of what their rights are online, and also help them develop the skills that they need in order to navigate this space, which is difficult. And here I want to just mention the 2014 guide, Human Rights Guide for Internet Users, which is also lying outside, and which is really an important document because it is directed at users of all ages and going in quite some detail about what are your rights exactly, what does copyright mean, what does it mean in terms of what you can do and cannot do, and what are your possibilities to address intermediaries or address courts when you have grievances. And that is important. Also, of course, it is important to be aware of the rights of others, and this is where the no hate speech movement comes in. Finally, just with our recommendation that we are doing now, media and information literacy programs are also considered very important, and they are part of both states' obligations to start from school to develop these skills and to promote them in curricula. And we do see, yes, states do already a bit. Yes, they could do more, probably, but I think the awareness of that is also just growing, how important that is from early age on. And it is also part of the responsibilities of intermediaries, that they also have gender and age-sensitive programs to ensure that users understand really what they're doing and what they need to protect their privacy also in future, for instance, or how to protect their own freedom of expression and the one of others around them. Thank you.
Any other good solutions, or I give a floor to Ms. from UNESCO?
Yes, I have the mic. Rachel Pollack from UNESCO. So I just wanted to echo a couple of points that were made. First, in response to the question from Dennis about should it be the Council of Europe, I think we've seen that a lot of the standard setting that has come out of the Council of Europe has led the way, is kind of on the frontier of many issues, and not beyond the 47 members that other countries have ratified some of the conventions, such as Convention 108 on data protection. But just to mention that UNESCO has also looked at this issue. We had a report out a couple of years ago about the role of internet intermediaries in fostering freedom online that looked at case studies of search engines, social media networks, and ISPs, and came up with a number of recommendations, namely that they should be more transparent, especially in the application of their own terms of service, which tend to be less transparent about, and in the removal of content, on which there's also less information than user data, requests for user information. Also, we work on media and information literacy, and I think there's a great potential not only for what governments can provide, but also in working in partnership with internet intermediaries to integrate it into their platforms. Judges are playing more and more of a role in setting beyond the legislative bodies and actually creating case law, and so that's why we've worked to educate judges on standards of freedom of expression on the internet. So that was my UNESCO plug. And now a question. I wondered, in the course of the expert group on internet intermediaries, it seems like public opinion has shifted a little bit, that 5 years ago, we had the so-called Arab Spring, 6 years ago now, and they were seen as this liberating force for democracy, and now everyone is very critical about the role of Facebook and Google in the spread of fake news and the spread of radical content leading to violent extremism. And so did that affect at all your deliberations within the experts committee? Did you have one idea at the beginning that shifted along the process? And were you engaged in discussions with the intermediaries themselves? And did their positions change during that period? Thanks.
I think Charlotte or Matthias could reply, but maybe a very short comment. I think where Council of Europe is trying to draft within the expert committees any recommendation, they are trying to get the word out as much as possible and to get all the stakeholders within the room actually to have their say and to actually have a discussion so that the standard setting would actually correlate with the society. In your question regarding fake news and all those alternative news and these, let's say, contemporary issues, in my opinion, the standard setting in the field of human rights, at least, should look very, very much forward and try to not be too much intertwined with the issues that happen daily, because otherwise it wouldn't really be a standard setting, it would be just a reply to yesterday's news, and I don't think this is the way the Council of Europe should make the human rights evolve for the 47 member states, which is a huge part of the world. But Matthias probably has a comment. No, Charlotte?
Always. No. If you talk to companies, you'll always get the answer, well, I mean, we would love, of course, to engage more broadly, but, we just don't have the time. And the thing is, I feel it's problematic if you do not think about the longer-term impact of applying terms of service to the development of human rights. So I think that companies should actually take a step back and think about what impact their action, their algorithms have on how human rights are applied on their platforms. And the Council of Europe and other organizations, including ICANN, are encouraging companies to do that, to engage on a broader basis. And just on a side note, to the gentleman, a couple of comments before who talked about the potential colonial dimension, arguing that it's a bit presumptuous of the Council of Europe or any other European organization to set standards that apply globally. I think you should not so much look at the geographic background of one organization, but rather at the normative pull of the standards which are developed. If an organization develops rules which make sense, which are based on human rights, and which make the internet a better place, I think it's not so important where those rules come from. It's about the normative, the pull of the rules that exist. And I think the Council of Europe, also with its Convention on Cybercrime, has shown that it has an international pull regarding the internet.
Thank you. Just to add very short pieces of information. First of all, yes, very much the Council of Europe wants to engage with different stakeholders that are all very important in the whole discussion on internet governance. And we have our expert committees that have representatives from civil society, from governments, and then we have observers that also include intermediaries. So we have had several sessions where we had different companies represented and also bring to the fore their points of importance. We also will be having an open consultation on our draft recommendation, and if you all please register with your emails, we will send it to you and alert you to when it is online on our website so that you can also look at it and provide your comments. Finally, when it comes to the public expectation, yes, there's strong public expectation today on doing more, regulating more the internet, etc. And we perceive that, of course, and that was one of the reasons why this committee was established. And this public expectation results in governments feeling more pressure to do something about it, but it also results in internet companies doing more, because they, of course, also don't want to lose their users. They want to maintain trust, they want to maintain an image that they're doing the right thing. And we have to be careful that they don't just do whatever. That we also, so this rule of law framework that we are trying to establish not only just binds member states, but it also is supposed to help intermediaries to establish certain standards, what they still also need to do, so that they don't just remove content because they think it may be hate speech, etc. Thank you.
I'd like to add, if I may, a few words back to the UN guiding principles. They provide a very good conceptual framework on the roles and responsibilities of states and enterprises. It's based on 3 pillars: protect, respect, and remedy. Governments have the obligation to protect human rights. Enterprises have the obligation to respect human rights, and then have a joint responsibility, states and enterprises, to provide access to a remedy. Now, this is also work in progress, but I find it's a very good conceptual framework.
Thank you. Christian.
As someone who's living in an Arab Spring state, there is a certain dilemma here. There are some illegal actions taking about censorship and tracking politicians and political activists. This is done by some governments using tools that are developed and sold by European companies. So I'm not talking here about some kind of global legislation or something like that. I'm talking about that some companies, and one of them is already went public, which is Hacking Team, is actually, it's hurting the human rights elsewhere. So how we should tackle this?
I would say that just as we have an export control regime for arms, we need to make sure that there's also an export control regime for cyber weapons in the larger sense of the word, and that includes software developed by companies which is sold legally, but which can be applied in a dual-use way. That is also as a tool to fight human rights defenders internally. But in addition to that, states also need to engage their partner states and ensure that the global human rights standards are applied there. And if they are, we sort of sidestep the problem of demand for that kind of software.
Thank you. I couldn't help but wonder while listening about all the discussion on the responsibilities of intermediaries, whether this is a discussion on trying to find a balance between self-regulation and co-regulation. I thought about it because, at least when it comes to protecting minors online, there have been a lot of initiatives coming at the EU level in the past year or even more. Thank you.
Thank you. Who would like to maybe give an expert view? Because very subjectively, I've always feared that over-incentivized intermediary is very comparable to totalitarian regimes. But any expert opinions from the panel to that remark? co-regulation, self-regulation.
Sorry, maybe just to say that at the Council of Europe, there is an action plan for children's rights and a strategy for that. And within that strategy, there is being developed right now a special plan for how to protect children's rights online. And that is being developed in a special expert committee as well. Not sure whether.
And on a practical note, just as the parents have a responsibility as well. Just as you wouldn't leave your children somewhere in town next to a place where there are drugs and they have access to pornography. Just like that, you shouldn't just leave your children out there in the internet to do as they please. They need to be taught how to engage with the dangers which exist. So it's not only a question of how to protect them from intermediaries, but also we have to ask ourselves how to ensure that parents and schools fulfill their obligation towards children.
Okay, microphone is there.
Oh, just to follow up on that, so I'm Patrick from UNICEF, and we are supporting the Council of Europe's process in developing guidelines for the realization of children's rights in a digital environment. And I think it's going to be an excellent process. One of my questions is actually related to it. This has just come up now, I think, from the audience. But I go to a fair number of events, both in terms of business and human rights overall, and also in terms of internet governance. And children's rights rarely feature. I think in general you do hear conversations about protecting children online, but you don't really hear conversations about the more holistic understanding of children's rights. And I think that doesn't just go to children's rights, but also to the rights of women, ethnic minorities, sexual minorities. And my question is, how do we fight against this? I think certainly we'd want these considerations to be mainstreamed and not to be siloed so that they're considered in every process, but it almost feels now as though they're being mainstreamed out of existence. And I think that's sort of shown today that there is a great Council of Europe initiative, but when we think about internet governance, we don't necessarily think about how it applies to children. And if we do think about children, it's in the context of protecting them, not so much in the context of their own freedom of expression and their own right to access the internet and how they use the internet to advance and exercise their own rights. So my question for you is how can we move the dialogue on?
I've got a feeling that it's been quite a numerous number of questions that are actually doubting with what Dr. Kleinwächter began, that we have this very common and very dear principle to all of us that all rights offline should be rights online. And it seems to be a lot of guessing whether it really is so, that we do have the rights that we have offline, that do we really have them online, whether they are enforceable. So I get this is the actual question, because children offline, we do perceive them as bearers of all the rights that there are. So.
I think we have here two different levels. One is the right as such, and the other one is the mechanism for the implementation. And if it comes to the mechanism, the only way to move forward is in today's world to promote a dialogue among all stakeholders. So, where you respect the various layers. So certainly a court decision is not made by a multi-stakeholder dialogue. But a lot of things, you can achieve by promoting the dialogue. So that means if you have the fixed rights in the convention, in the law, or in the treaty, then you have a criteria, and then you can stimulate the discussion. And if the body which promotes the discussion has a certain authority, it will make the outcome from the dialogue stronger. I think the work of the Council of Europe with the so-called expert groups has created an own legitimacy, and what comes out from this, I think, is a helpful instrument. And I think also EuroDIG has already from the very first day introduced a practice which is different from the United Nations IGF. So it has summarized the outcome from the workshops in form of messages. So certainly what an EuroDIG message is not a treaty, it's not a right. But if you know, 3 or 4 strong messages come out from such a meeting, then, you know, other actors, including intermediaries or governments, you know, will take note and say, oh, something is going on here. And I think this is helpful. And it's not only governments and intermediaries, it's also other constituencies. You know, what I've seen over the last years is that, you know, within the internet governance community, with all the differences we have, there is a common consensus. So we repeat main things from year to year and have a certain agreement with some minor differences. But the internet is now discussed also in circles and groups which have nothing to do with internet governance. Look in the military, when they discuss questions on cyber weapons and cyber war and you know, how to protect the public core of the internet, how to protect electric grid and you know, the hospitals from cyber attacks, you know, they ignore totally the discussion here about right to freedom of expression, right to privacy. I was in a G20 meeting recently on the Ministers for the Digital Economy. Germany is the chair of the G20 now. So, and if you see all these business people around Industry 4.0, Internet of Things from the various industries, they have no clue what we are discussing here under internet governance. So that means the 3 big fields of policy making, security, economy, and the human rights, are not interlinked. So that means the target of our discussion should not only be, you know, intermediaries or, let's say, private sector members and governments. It should also the constituencies who are more active in the digital economy and the constituencies active in cybersecurity, because you can reach sustainable developments only if the security aspects, the business aspects, and the human rights aspects are more or less, I would not say harmonized, but interlinked in a certain way. And I remember the British foreign minister in the Helsinki conference 40 years ago, when we had a similar constellation. There were security issues, basket 2 were economy, and basket 3 were human rights. And it was the Soviet Union who wanted to have security, and the West who wanted to have human rights, and the British foreign minister argued, without X in basket 3, no X in basket 1. So it was a very clear deal. If you want to achieve something in the security field, you have to make concessions in the human rights field. And you know, if you now translate this logic of the, let's say, the Helsinki process into the cyberspace, you could argue in a similar way that you say you will not achieve cybersecurity if you ignore human rights. And by the way, we will not have sustainable human rights implementation if we live in an unsecure world. So this is a process which goes in both directions, and we have to take into consideration basket 2, that means the digital economy cannot be ignored. I think to broaden this understanding is important also for EuroDIG, that we reach out more to groups which are also discussing internet issues but had nothing to do with EuroDIG in the last 10 years.
Thank you. That was very entertaining. There one more microphone there, I think.
Thank you. Jutta Koll from the German Digital Opportunities Foundation. I just wanted to pick up again on children's rights in the digital environment, because we really appreciate the initiative that the Council of Europe has undertaken with the KHENF and KNF-IT on drafting these guidelines. And if you look back that we have the UN Convention of the Rights of the Child since 1989, I think it's high time to put now also the focus on these rights. It has taken a long time to understand that children's rights as well as human rights are relevant in all areas of life, and the digital environment is not something separate, it's now horizontal. So we need to understand that children's rights in all areas are affected by the digital environment, and it just take the opportunity to advertise the flash session we have tomorrow afternoon at 4 o'clock, which is dealing exactly with children's rights in the digital environment, and we have there the opportunity to talk a little bit more about the guidelines that shall come out. I think they shall be adopted by the Ministers' committee in January 2018. So, and then probably at the next EuroDIG, we will have the opportunity to discuss this a little bit broader. Thank you.
Okay, one more question. Wolf, behind you, Marianne.
Good afternoon, Marianne Franklin, the Internet Rights and Principles Coalition. The title of our meeting this year is Digital Futures. I'd like to indulge, if I may, in 1 minute of future thinking. Hands up anyone who's seen Planet of the Apes. Either the first version with Charlton Heston, bless him, or the second one. Okay. Just imagine, 100 years from now, a spaceship crashes on an unknown planet and finds its way to what seems to be the remnants of a past civilization. I won't give away the ending for anybody who has not seen the film. What remnants of these conversations, since at least 2003, what remnants of 80-odd charters, Magna Cartas, principles, structures, programs, initiatives, educational outlooks, judicial rulings, various intergovernmental bodies, local organizations, schools, universities, what remnants would the women who came out of this spaceship and found their way to this lost civilization, what would they find? And in what state would it be? Would it be comprehensible? Would it be in one piece? Would it be a conglomeration of many, many, many declarations, principles, laws, and judiciaries? What I am missing after 10, 15 years of conversation, what I am constantly missing is the links in the conversation, in the reference lists, in the rulings that link to each other, that go backwards, that go sideways, that go forward. This constant erasure of what came before I find very, very troubling. So let all 82 charters of principles, let this charter or that guidebook, let them all breathe and be visible. So when that spaceship lands, they will find not just one broken thing, they will find many things, and like an archaeologist, they will find enough so that they can reconstruct what happened before, so they do not make the mistakes of what happened in the past. It is not an accident that it took so many years for the Universal Declaration of Human Rights to be accepted as soft law. So it does need time, but I think we're wasting time if we're not careful. I'm speaking for myself as well. So in that sense, it's just think in the future for a minute. And so we can think horizontally and no longer in the silo thinking. It's not just the rights of children, it's the rights of persons with a disability. These are enshrined in international law. It's not just the rights of women, it's the rights of everyone to have a free education. So we need to work together a lot more and let it be seen in the record. And that record is now online. People Google that record. So are we referring to each other sufficiently so that the future generations can find out where it all began? Thank you.
Thank you, Marianne. I think before getting our experts on the panel to their closing remarks, I think it's a very good practices of EuroDIG, as already mentioned, to have messages. In order to have messages, of course, we have to have rapporteurs who have carefully listened in and try to scribble down a few main points that came out as something very, very relevant for this workshop. The rapporteur is Ms. Marja Pild from University of Tartu and attorneys at Law Trinity. So Marja Pild, if you would come here, I would give you a microphone and let's see what you heard as a message for the Planet of Apes.
Sadly, I have not seen the film yet, but this is something to expect. Thank you very much for the discussion and the content and all the thoughts. They were really interesting. So now to provide the conclusive remarks and the 4 main points as such. Firstly, I will talk about the interpretation of human rights online. Secondly, obligations of the states. Then obligations of the intermediaries, and lastly about education, but this all very shortly, so you can get to your coffee break soon, I promise. So First point, the interpretation of human rights online. We have heard that there is no need to reinvent new internet-specific human rights. The interpretation of human rights should be dynamic, and interpretation must consider the technological revolution as such. Secondly, the obligations of the states. The negative and positive obligations of the states in relation to the internet must be clarified while taking into account and reminding the states the principles of multi-stakeholderism and legality. Third, obligations and rights of the internet intermediaries. Functions to ensure human rights should not be delegated to intermediaries. Nevertheless, intermediaries should aim at respecting human rights, refrain from discrimination, and aim for transparency. And lastly, education. Informing people about their human rights online is crucially important. Media and information literacy programs should be promoted. It is also a responsibility of the intermediaries that users would be more aware of their rights. So this would conclude my conclusion,
Yes.
and thank you for your attention.
If anybody feels that one or the other message has been totally been neglected by the rapporteur, just find her later, grab her, and she will gladly add your message. But with what should the listeners leave from this workshop in mind? What would be the final conclusive idea that they should be thinking about during having a nice cup of coffee? Mr. Wolfgang would be first, probably? Or anybody else? You are free to choose the lineup.
You know, whatever will happen in the future in the cyberspace, we should put human rights on the first place.
And not to repeat that, let's also not forget about the rule of law.
Okay, so human rights, rule of law, fundamental freedoms should need also have to be protected.
And let's see it as a joint responsibility of states, enterprises, but also individuals.
I won't try to conclude, otherwise it will become very depressive. However, actually it was very, very enlightening for me to sit here. Thank you for bearing with us. Thank you all the panelists for taking your time and sharing your thoughts with you. It was very interesting. Thank you all the listeners, and now you can have your coffee or any other liquor of your choice. Thank you.